Loft Board. I'd like to welcome you to our April 21st, 2016 public meeting. If anyone can't hear me, call me now. All right, we first turn to a vote on the minutes from the February 18th, 2016 public meeting. Are there corrections or comments on those minutes? Is there a motion to accept the February 18th, 2016 minutes? Mr. Gregory, thank you. Do I have a second? Mr. Barrett, thank you. Mr. Barrett, all members.
Mr. Carver.
I'll have to pass on that thing because I wasn't here.
Mr. Barrett.
Yes.
Mr. Gregory.
Yes.
Chairperson Fisher.
Yes.
Mr. Delaney.
Yes.
Ms. Golden Rivera.
Abstain.
Mr. Shepherd.
Yes.
Ms. Sheldon.
Abstain. Motion fails.
Warrior,
I wasn't here.
I
wasn't here.
were you there for the March, for the February meeting?
Yeah, I thought we were going on the March. No,
February.
Oh, I'm sorry.
February.
I'm sorry.
February,
Yes.
were you all there?
Yes.
Were you there too, Ms. Golden?
That was in February.
Okay, so what are your votes then?
Yes.
And both of them were yes. Okay.
All right. Passes.
So it's one abstain and 6 in favor.
We turn now to a vote on the minutes from the March 17th, 2016 public meeting. Comments or corrections on those? There, motion to accept the minutes. Mr. Barber, thank you. Someone else? Second. Mr. Gregory, thank you. Mr. Barrett, roll the numbers, please.
Mr. Carver.
Yes.
Mr. Barrett.
Yes.
Mr. Gregory.
Yes.
Chairperson Fisher.
Yes.
Mr. Delaney.
Yes.
Ms. Golden Rivera.
Abstain.
Mr. Shepherd.
Yes.
Ms. Sheldon.
Abstain.
6 in favor, 2 abstain.
Motion passes. Lanny Alexander, our executive director, will now give her report.
Good afternoon, everyone. I don't have a whole lot to report today. I sent the board on Monday, I sent them the statistics for this month, with building count and the milestones. But to summarize, we do have a total of 333 buildings in our jurisdiction. And then I broke it down for everyone. There are 229 buildings that were 281 buildings, and 104 buildings that are our new buildings. We had an interesting statistic that in the 281 buildings, old buildings, of the 229, 120 have either 7B compliance, a TCO, or a certificate of occupancy. That's a good number because we want to make sure that we're moving everyone over towards being fire safe. So that was good. We only have 10 of the new buildings that have achieved those milestones. Since the statute of limitations has been lifted, we have had 39 new applications for coverage. And that's really all of the news that I have for you today. Are there any questions or comments?
Do you have any update on the heater situation?
Well, as you know, we sent out a letter. We've asked all of the owners to look and see if they have the heaters and to go in and inspect and make sure that the heaters that are there are properly installed, that the pipes are proper. We are not following up on that, but we did, as you know, ask the tenants to come and tell us if this was not something that was happening in their units. We did have one tenant who came and said that while the owner had said he was going to come and inspect the heater, he hadn't seen the owner as of yet. We called the owner that day, and that day the owner went and brought a plumber in and inspected the unit. And the tenant had already put in a CO2 detector. And that was the only tenant that we heard from.
And how did you physically mail to the owner? How did you communicate with them?
With the owner, you mean in that particular building?
Pardon? No, across the board.
We sent the notice to every owner that we have registered through our system. We pulled out every address. So they were all sent a notice. And in addition, we sent the notice to all of the attorneys that represent both the tenants and the owners, so that they were also on notice of what we were asking them to do. We also put it on our website. So the only thing that we really did not have the manpower to do was to send a notice to every tenant.
Right. And you sent those to the owners through regular postal mail?
No, I think we emailed to every owner. Did we send them to the owners too?
Mail.
We mailed them too.
Thanks.
You're welcome.
All right. We turn next to the summary calendar. There are 14 summary cases. These cases are voted on as a group. They are Bernard Belkey, 80 Barrett Street, PO 001, Amber Lacey, 430 Lafayette Street, PO 06, Simon and Tatiana Hochstein, 143, 155 Oakland Street, aka 1-19 Hope Street, aka 314-330 Metropolitan Avenue, Brooklyn, PO 009, Lisa Gee, Christian Wasserman, and Denise Langenecker, 357 Bowery, R 0338. Thomas A. Taylor, 517-525 West 49th Street, TN 0087. Vanessa Liberati, 143-155 Roland Street, AKs, PR 1024. Nancy Wong, Carlos Ferraris, Philip Cranky, and Paul Marlowe, 147 West 29th Street, TR 1090. Jeffrey Owens and Ava Fedorov, 143-155 Roland Street, AKs, TR 1097. Thank you. Carlo Waldron, 143-155 Roland Street, AKs, TR 1120. Asa Pingree, Andrew Jordan, Stephanie Smith, Daphne Fitzpatrick, and Jeffrey Seabury, 155 Oakland Street, with the AKAs, TR 1173, Josephina Louisa Helstein, Danielle Benedict Schneibel, Margarita Cruz Gallos Lucas, Evan Sedgwick Sarinian, and Elizabeth Redmore, 143-155 Oakland Street, TR 192. Ryan Figueroa, 143-155 Oakland Street, TR 1250. Stephen Kobrick and Gary Schmadock, 447-449 10th Avenue, TR 1257. Anthony Patty, 143-155 Oakland Street, TR 1268. Comments, questions? I'm done reading these. Are there any comments or questions on these cases? Sorry. Mr. Delaney.
Yeah, I have a couple of questions. Case number 2. This was docketed as one of those occupant cases, right? Protected occupant. But the building doesn't have an IMD number. How are we able to docket a case and proceed on a question of protected occupancy of a building that's not registered?
Somebody files an application. And this was, as you might remember, it came along, was done after the application for coverage for the same building. So at the time, there was an application for coverage, and then Ms. Lesiak filed a protected occupant status on her own. to join the other two. Does that answer your question?
And the application for coverage is still pending. Case number 7, I'm going to ask again that we vote on that separately because I want to vote against it. I see it's been brought back for a prior calendar in the same condition. Case number 8, the proposed order describes one of the parties as an overtenant, which is not a term I'm familiar with in our rules. Would you define it for me?
Well,
As opposed to, I guess, a prime tenant or?
it's a term that they use in the application to describe themselves. So we just copied it from the application.
Okay. Number 10, I don't understand the order completely. The last paragraph, we're directing the current owner of the building to register the units occupied. And my first question is, it's been my understanding of our past practice that we don't process these kinds of withdrawals with prejudice until after the units have been registered.
Yes, that's true.
But here it would appear, since we're directing the current owner to register the units, that the units have not been registered.
This owner has indicated to us, because as you can tell, this building has several cases on the calendar.
A record-setting number of 10.
Right. As you know, as the board knows, we prefer to deal with all of the cases that are ready for a building together, to the extent that it's possible, of course. So we've been holding these cases back to sort of try to make them all happen at the same time, so that all of the coverage issues for a building are dealt with at the same time. So what we've done here is that for those units that the owner has not registered, we are directing him to register with those units that we're finding covered. So in the master calendar, there are units that we're directing the owner to register because we're finding them covered, and so it would just be easier to have all of one application, one registration listing all of the units that we're deeming in this meeting covered, units that he agreed to register, and units that the board is granting coverage for.
So in this case, however, the tenants, for whatever reason, not only withdrew their application, they withdrew it with prejudice, based on the former owner's commitment to register those units.
Isn't it right, Scott?
Yes, that's right.
Pardon?
The current owner is the owner that has agreed to register all of these units.
Oh, okay. That was not clear in the order itself. So now I've withdrawn my application with prejudice based on the current owner's promise to register the building. And the board is threatening additional proceedings and fines. But what's my recourse as a tenant now that I've withdrawn the prejudice?
Well, I don't know the exact language of the agreement, but the withdrawal with prejudice was contingent on him registering.
If he doesn't register, then the withdrawal doesn't count.
Even if we adopt the order? Okay, well, I'd like to vote against that one too. And my second question, the law court is directing the owner of the building to register these 4 units. But are we making any finding one way or the other as to the protected occupancy status of the applicants?
No.
No.
Unless the agreement says, and I don't remember right now, I can check. The agreement says, I agree that, the third floor unit is an IMD, was residentially occupied for the window period, and Martha Cruz is the protected occupant of the unit. Then when the registration comes in, we would check to make sure that those units are all registered and all people are registered.
Okay, all right. Number 11, we have the same case where Red Sky Jay-Z Golding says it's going to register the unit. In this case, it also says we'll register the tenant, but again, that hasn't been done.
No.
Okay, all right. I'd like to vote no on that.
What's this?
You can pull that aside.
Anyone else? Comments or questions on these cases? Is there a motion to accept the summary cases minus number 7? I'll take this a second.
7, 10, and 11 are wrong.
Pardon me?
Numbers 7, 10, and 11.
You said you didn't want to vote for them, and that's fine.
Want to vote no?
And you may, but we'll take a vote from the whole board. That's your prerogative, if you don't agree with it, is to vote no.
But I want to vote yes on all the others.
Well, it's a question of how you present it.
I see.
I
How
call it
you
out.
present it.
Yes.
So let me,
So you have to present it minus.
Minus those.
let's do that. So,
Thank you for your.
Pardon me?
I'm just thanking Ellie.
all right, let's try again. So is there a motion to accept the summary cases minus number 7, 10, and 11? Sheldon, I'll take you as the first. Do I have a second? Mr. Carver, thank you. We're so quick here. You call the members.
Mr. Carver,
Yes.
Mr. Barros,
Yes.
Mr. Gregory,
Yes.
Chairperson Fisher,
Yes.
Mr. Delaney,
Yes.
Ms. Golden Rivera,
Yes.
Mr. Chapman,
Yes.
Mr. Sheldon,
Yes.
8 in favor.
Thank you. The motion passes. Mr. Delaney, would it be okay for us to vote on 7, 10, and 11 together?
Sure.
Okay. So is there a motion to accept the summary cases numbers 7, 10, and 11? Mr. Gregory, thank you. Do I have a second? Ms. Sheldon, thank you. Ms. Rivera?
Mr. Carver,
Yes.
Mr. Barros,
Yes.
Mr. Gregory,
Yes.
Chairperson Fisher,
Yes.
Mr. Delaney,
No.
Ms. Golden Rivera,
Yes.
Mr. Chapman,
Yes.
Mr. Sheldon,
Yes.
7 in favor, 1 against.
Thank you. Motion passes.
Can I just say that these 10 cases, it's such a mess. And I don't know if there is a way of making this thing simpler. Boy, going through these cases was just almost impossible.
Can you imagine? Oh, we finished.
And after a while, I couldn't remember one from another, because the language very often was the same. But I don't know, I mean, I was just, spending hours and hours, just satiated after a while. It was, it was just coming out of my eyes and ears.
We totally agree with you. It was this particular building was extremely difficult for us to deal with on many, many, many levels. Trying to make sense out of everything and cover everything and understand all of the different things that went on. So we did our level best, and I'm sorry that it was still confusing, but we really worked very hard to try to make sense out of what was going on in the building.
So you think these are the idiosyncrasies of these really large loft buildings? I think 475 N Street was a little simpler. And that's a huge building. There's probably more lofts in that building than any other in the city. And that seems to sort of move rather judiciously along.
There were
But I
some,
just hope this doesn't start a whole trend.
we hope so.
You know, not only the landlords are interested in what they want to do, and their lawyers are interested in supporting it. Just making life difficult for everybody, the landlords, the lawyers, and then us. And let's forget the tenants because they're price
It was a very difficult time. We had all of these settlements on the one hand, we had 2 different types of hearings, and then we have one more, which I promise you is coming next month, with regard to this building. There are 2 more cases that we could not do for this month, although we tried. And that would be one more, it's a summary coverage, summary case, and then the what is it called, contested coverage case. That is the sort of final denial of this building, and then it will rest.
Just want to that notwithstanding.
I can't hear you.
I'm sorry, I just want to see notwithstanding the complexity, I think the decision was well made.
Thank you. Thank you.
Was able to hone in on a lot of the issues that I thought were made to the
This is also a situation where the attorney who was handling all of the World Street cases is no longer with us. So we had to put it all back together again and do it all over again. So that made it even more difficult. Because she really knew it. She really knew it.
I wrote you earlier this morning with a suggestion maybe you could try to give us some context around this building.
Yes. So I looked up, the owner in 2012 registered 11 units. If everything passes today, we are adding another 8 units, 3 in the master cases and 5 in the summary cases. There were 11 additional units that requested coverage. Those units, the tenants withdrew their claims and vacated, so those won't be part. So at the end of today, it should be 19 units in Roebling Street, Metropolitan Avenue, and Hope Street. And the owner has not filed a marriage statement.
The owner hasn't filed an error.
No, but they are working on it. We do know from the architect that they are working on the marriage statement as we speak.
And the building has an IMD number, so there's been no question about this being one building.
No, there's no question. It was being registered as one building.
And we accept it then.
Yes.
All right. And, I want to state for the record, once again, I have repeatedly spoken to, and I've written to the chairperson and the executive director, the fact that we get these cases on Friday and are expected to come in and review them and come in and talk intelligently about them the following Thursday in a thicket of this complexity. And I know, case 15, Magnolia, the recommendation that you received from Kevin Casey was dated May 20th, 2013. So you've had close to 3 years to try to make sense of this particular document.
That's not really true. But
And I've had 6 days. So I want to reiterate, in cases of this magnitude, that I think board members should be given more time. It's very hard to feel that I'm fulfilling my role, and we'll get into some of the particulars of why I'm troubled by that. And obviously, I'll tip my hand and say that today is protected occupant day. But also, the board in a couple of these cases is making determinations with regard to whether or not a unit is the tenant's primary residence. To my knowledge, we've never done that. I don't know where the authority for that resides in the board's, in the Loft law rules. So I just feel these things are all over the place. And again, I'd like these remarks put in writing in the record, not referred to the YouTube video. know, I think it's really asking us to either make a superhuman effort to devote the time, as Elliot pointed out, or to just be kind of rubber stamps and say, oh, well, this looks okay, sure. I vote yes.
I'd like to address one point that you made with regard to the Magnolia report and recommendation. Yes, it was issued in 2013, I believe you said. But this case and the Doris case all relate to another case that you'll get next month, which is a contested coverage. And the owner in that application raised the same issues that he raised in the answers to Magnolia and all of the other. So what we were doing is waiting for the ultimate outcome in the LN case, in the contested coverage case, to deal with the issue, which were the very same issues. So we were waiting for the LN outcome to come through oath and that process, so that we can move forward with all of the road and street cases. Because they were exactly the same defenses that he raised in the LN as an applicant, moving forward, requesting that the board, remove from its registration those units. And those units were the subject of several cases. And that's why we just sort of held off until that issue was resolved and came back from oath, so we can deal with the entire thing at the same time.
The LN case?
Yes.
Which is a
Contested coverage.
Right. So the landlord's contestation coverage case, which is a piece of the puzzle, is not before us today.
Well, and the reason why it's not before you today is because he settled it. Basically what he said is, I'm not going to put forth any evidence in my contested coverage case. I already did in Magnolia, but did so well after Magnolia. He did it in the context of Doris. So it's all intermingled, and we apologize for that. We had to bring these cases first, and then we were going to bring the LN case, because it dealt with the very same issues that we're resolving here today.
And these need to be brought first
Because the LN case is contingent on the findings in both of those cases. Now, the LN case, the contested coverage case, while it was filed prior to Judge Casey writing his report and recommendation in NOVA, he states quite plainly that he's not going to deal with the LN, the contested coverage case, in his report and recommendation. So it was not there, and because he said that, we couldn't just add it, piggyback it onto NOVA. Then we had the Doris and Hernandez case, which came later, and in that transcript, that's where we find the owner's representative saying, I'll rely on whatever happens in the judge's findings in these cases. I'm not going to provide any more proofs. So we pushed those together. We wanted to do the LN with it, but we could not do that for administrative reasons. And so this is what we have. And while it may be complicated for you to read something that has been gone through and sifted through at great length by the staff, and it may be, complicated for you to read the final outcome, we spent months on these cases trying to work through the morass of the record, what the attorneys did, what the judge did, and tried to make everything come together. So, I take exception at, you were saying that we had so much time to do it, and you have so little.
with what do you take exception?
Well, I think that the fact that you were getting the synthesis of what we have done While I know that you are really very thorough in reading the record and all of those things, it's there for you and it's been synthesized, and you get what you all need to make your determinations. It's nothing to compare with what we had to do to get this case understandable for all of you. That's all I'm saying.
I see. Oh, well, I definitely agree that the staff has had to do a tremendous amount of work.
That's all I'm saying.
The place where I feel I really am not
Mr. Lane,
capable
I'm
of...
not here to argue with you. I get what you're saying. That's not.
So if I can just make a suggestion, I mean, because we have we want to move as many cases forward at each of these meetings as possible, right? So we try to get to these meetings with as much stuff as we can. To do that, we try to work until the last minute. I understand that people have competing priorities. If the board wants, we can do meetings every other month, and we would then provide a substantial number of materials, but we would do it with a little bit more time. But we wouldn't be meeting every month, and I'm not sure that's the best way to handle things. We do the best we can. We don't want to hold cases back. Otherwise, I'm not sure where to go. So if the board wants to do meetings every other month, you're going to get more materials, you'll get more time. But at the end of the day, you may end up being the same issues, right? More stuff.
Well, as you know, in my...
Is it possible to send us what you have when it's ready, just on a serial basis?
It is ready on Friday.
All of the cases?
We have, yes, all of the cases. We work right up until the moment that I send them out. We work nights that week before, we are working really hard to get these in their finished product, and they are not done until I send them out. We don't have lead time. It's not like you're sitting with a computer all ready to rock and roll. That's not how it works. And we are finishing them, proofing them over and over again, making sure that we have all of the backup, making sure everything is correct, right up until the last moment. Because if it were not true, I'd send them out earlier. Really, I would.
Well, for me personally, I don't think we need meetings by Dr. early, because I don't have time either, so Friday's fine.
I mean, I agree. I think to hold off every 2 months, see, the problem with this is the fatigue factor. And instead of dealing with 20 cases, we're dealing with 40 cases. It would even be worse for us. So let's try to do the best we can as we have over the last 100 years. I mean, I think this is really almost unique in terms of the problems that this agenda has caused us. So you all do a terrific job.
We are facing in the past.
Your ability to analyze these things are amazing. So.
She does a great job.
Yeah,
We all do
really.
a team.
In these past 2 years, we have had to deal with a new influx of coverage cases that we didn't have for many years. We have the issues of coverage that are different from anything we've had before because we have added eligibility requirements, a whole new series of types of analysis that we have to go through. Then we have the protected occupant issue, which we are, grappling with. Then we have the other eligibility. Next month, you're not only going to get protected occupant. Next month, we're going to get more window cases. And after the window cases, I'm told that coming down from Oath soon will be the use group cases. So none of these are easy. And so, but once these are done, then this will ease up and it will become like it used to be before they amended the law. So we are sorry, but really these questions of law and fact that we have been grappling with are, so difficult that we are really up to the deadline every month.
While I appreciate how hard the staff works, and I know we all have a tendency problem is your self-designated deadline, Friday, 5 p.m., prior to the next Thursday, gives us a very short window of time to address what in this case are a series of complicated issues. And in this circumstance, I really don't feel that I'm able to do the job that
Then what we should do is give you fewer cases. And it'll just spread it out longer.
But in the alternative, I made two suggestions in my letter. One was, what if we got 2 weeks? What if you had until the one Friday before, and that was your deadline?
Mr. Delaney, you're not hearing what I'm saying. We work up till the day that they have to go out. If they had to go out 2 weeks earlier, we wouldn't be ready. You would have no cases, because they're not ready then. So either you want us to go 2 weeks earlier, that's fine, we'll do one case. Because the rest of them aren't ready. And so we're going to have to start dribbling them out, because you want time. And I don't have the time. Neither does Martha. We want to get as many cases as we can through to you. We work very hard to do it. We are sorry that we cannot get them to you sooner. 2 weeks, you change the deadline, you'll change the way it gets sent to you. You'll change what you get. So, there's no good way to do this. There's no easy fix for you or for us.
And the second, well, I guess, what you're telling me is all the cases come out of the oven in no time. None of them are done until, voila, all of them are done. In this case, I don't see that there's been a lot of proceeding going on in the past few months on most of these Rolling Street cases, I guess we can refer to.
Which ones? You're talking about the summer cases?
Well, the 2 master cases and the 8 summary cases, all of which involve just one building.
I'm not sure what you're saying to me, I'm sorry.
Oh, okay. Well, you said we work out things till the very last minute, and none of them are ready till all of them.
Okay, you have one other thing you wanted to say. You said the second thing that you had suggested?
Yes, the second thing I suggested is that board members be allowed as a courtesy to ask that a case be tabled for a month if they can't have the time to work their way through it. Otherwise, you just put, this is not due process.
And we can vote on the tabling as well. We can make that a motion. We can always make that motion.
Yes, I know. And as you know, last month, through an unforeseen set of circumstances, I didn't get the cases till Monday of the week because I just got accidentally dropped off my circulation list. I said I'd do my best to read through all the cases I was able to do. It was bloody hard after the weekend. So I'm not out to be obstructionist, but I got to tell you, these are very uncomfortable. And I'm sure when we get to the window cases and use group cases, there are going to be loads of those as well. So this is not. Yes, there may be a time come 2017, 2018, when we'll go back to cases where we're not dealing with the first impression or things that, and we'll be dealing with things that fit into patterns that have been established. But right now, that's not where we are.
Okay. And I appreciate everything you've said, and I've heard what the other members said. Those other members, we've asked this question before. If you want to share some ideas on this, I'm happy to have it through email, but I think given we have these complicated cases, we should get to those if you don't mind. I get it. We do the best we can. Our short-staffed, our operations are operation, and that's our issue. So, we move on. Great. Okay, first coverage case is Peter Mignola et al. 143-155 Rolling Street. The AKA is TR0797. Ms. Cruz, present this case.
Between August of 2010 and February of 2012, various occupants filed for coverage of 9 units. The owner's defenses against coverage in that manner 4 roommates does not create single room occupancies. The Loft Board rejected this argument in Loft Board Order 4333. The owner's argument that commercial activity in a unit precludes coverage is also incorrect. The art gallery and recording studio in these cases should not preclude coverage for these units. The spaces were both commercial and residential, were used for both commercial and residential purposes. The areas used for commercial purposes were not separate from the rest of the unit. When the areas were not used for commercial purposes, the tenants used the areas as living rooms. In the report, Judge Casey recommended Article 7C coverage for the units. The staff recommends that the board accept Judge Casey's recommendation for all of the units except Unit 5E at 153 Roebuck Street because Mr. Reinack settled his claims on February 23rd, 2015. Judge Casey also recommended protected occupant status for the applicants. The Loft Board rules about protected occupant status are found in 209B. In his report, Judge Casey summarized the standard for determining protected occupant status, but only included 209B1 and 209B2, but did not include 209B4. Where there's no prime lessee, Section 209B1, B2, and B3 determine eligibility for protected occupant status, depending on whether the occupancy began before or after the effective date of the applicable law. However, when there's a prime lessee, 209B4 governs. According to the plain language of 209B4, the prime lessee is the residential occupant entitled to protection if the residential unit is his or her primary residence. Using this analysis, the staff recommends that the board find that the protected occupant claims of Mr. McNola, Ms. McMillan, Mr. Reeder, Mr. McCullough, Mr. Gorman, Ms. Wilson, and Ms. Beijing be granted, and that the claims for the protected occupant status for Mr. Slater, Mr. Rosenthal, and Ms. Rivera and Ms. Gorman is denied. Although Ms. Rivera and Ms. Gorman occupy their respective units with their spouses, who are protected occupants, they are not protected occupants under 209B4 at this time. However, as spouses occupying an IMD unit as their primary residence, they are entitled to succession rights pursuant to Section 208.1 of the Loft Board rules, and they will be entitled to be named on the initial lease that is issued upon removal from the Loft Board's jurisdiction.
Thank you. Comments or questions? I have a question actually.
On page 4.
You can do it, right?
Page 4, it says, you're talking about whether it's a residence and you say it had sofas and chairs, but is there a technical definition of what has to be in a unit for it to be a residential unit? A kitchen, a bathroom, or anything like that? So what are your criteria for being a unit?
Yes, well, the unit has all of that. The issue here was that whether the space that they were using as the art gallery was also being used for residential
I know, that wasn't my question.
Okay.
My question is, it's a general question.
Okay.
What are the criteria for a unit to be residential? So sofa chair A doesn't say anything.
Well, the comment that was made here was related.
In general, we've had these cases before, where we look to see whether there is a kitchen, whether there's a 3-piece bathroom, whether there's a sleeping area. Now remember, not all of these things happen in each unit. So sometimes we found, the Loft Board has found in residential, they found residential use even though, let's say, a bathroom is out in the hallway. It's an overall indicia of residential use. And the standard has not been terribly strict. We have found units that have had bathrooms but a hot plate, and sleeping area and living area, or the bathroom has been out in the hallway but there was a kitchen. And these were, I think, recent cases that we had before the board, as well as a lot of old cases. So it's really a number of things that we look at for the indicia of residential use, as opposed to being something that's just being used commercial and is a cut, and there's no other indicia of which we've had cases like that in the way past, where the Loft Board found that somebody who was just sleeping in the unit occasionally did not make that residential use. Does that help?
Yeah, I mean, if you have an office, there's a bathroom down the hall, someone's sleeping in it, and they have a hot plate, it's still not residential. So it's a bit fuzzy.
Which unit are you?
Now, case 15, on
Yes.
page 4, it says they're made a decision that was residential because it's sold in it.
I don't know which is the unit.
Third floor unit at 147 Roland.
Yeah, I was looking at page 4, there was this comment, I was like,
The area has couches and chairs.
man.
Right.
So for, in that instance, what we were looking for was to see whether that was strictly being used as commercial or whether it was also being, because it was the claim of the owner that that whole portion was just being used for commercial purposes. And the tenants of that unit said, no, we also used it in the off time as our, like our living room. So
Or was
that's,
the kitchen in the bathroom somewhere else?
yeah, it was a very large unit and that was just part of it.
Somewhere in there was a bathroom.
Follow up with that one. I'm curious, who's the we? You keep saying, is it you or the inspectors or
I'm sorry,
the we that you said we determined? You said-
we, it's the royal we, it's all of you.
It's not,
you
it's
guys.
not the Department of Buildings Inspector.
No, this
Right.
is in 208 of the Loft Board rules. It talks about residential occupancy and what residential occupancy consists of. But in addition, we have a lot of case law from the 281 buildings where the question did arise, was this, because you have to, it has to be, it can be commercial, but it cannot be commercial with just incidental residential use. It has to be incidental commercial use to the residential use. It's a mixed use unit. That's fine, but they look and see whether there's indicia that it's mainly used as a residence.
I have another question that doesn't relate to use. The people in number, Carla Waldron, number 9, they're the same applicants? What is it? If you look at case number 9, it was Carla Waldron, and they were the same people who applied or asked to be copied.
Summer case, you mean?
Yeah, look at summary calendar number 9, Carla Waldron. Second paragraph of the order on number 9, it's the same names.
Okay, so what was your question?
So Waldron was dismissed with prejudice. Is that because the owner agreed to recognize her as a protected tenant?
Waldron?
Yeah, Waldron went away, but all these
Right,
people.
Waldron agreed to withdraw.
And so where is she now in the whole system?
She's gone.
She's gone.
She
But
left.
Has it moved out?
She left.
Mr. Gregory?
Yeah, and just a question for my own understanding for page 7 for unit 4A for run it's Biogen.
Mhm.
So I just wanted that she's considered a protected occupant based upon the fact of her grandfathering. Is that basically the concept behind her being a protected occupant?
She was there prior to the effective date of the law. She maintained,
No, that's not,
No.
yeah.
enter.
Oh.
Yeah, we don't use it, we don't describe it that way.
Okay.
We say prior to June 21 of 2010, she was there in the unit. In this particular case, the prime lessee and the Bradfield was served with the application, he didn't answer. She's in possession. He didn't assert a claim for protected occupant status, so therefore, based on 1 and 2, meaning 1, section 209, it says that, if you're the residential occupant in possession, and 2, then you don't have to have the owner's consent, and you're the protected occupant.
Okay.
Okay?
So for the 1 and 2 and 3, the difference is the date. So if you're there before the effective date of the law, and all you have to do if there's no prime lessee is to have been there then you're the protected occupant. But if it's after, if you took possession after the effective date of the law, then you need privity with the owner.
Yeah, I noticed that the staff is recommending fact-finding of primary residency for certain tenants. What's the standard by which you are measuring primary?
Well, it's whether you've represented this address as your address in tax returns and government records, like tax returns. Whether, what's the other thing? There's three things. With the time spent there and there's three.
I was concerned about one of the tenants where you're recommending that we find primary residency. It's a gentleman whose wife and child resides in the suburbs, and we don't have a tax return. That would be the clincher for me.
We have driver's license.
What we had for Mr. Aycock was the testimony of, are we talking about Mr. Aycock?
The ground floor.
Or Mr. McNulty?
McNulty.
Mr. McNulty. And in McNulty, we had three people testify to the fact that, and there was all kinds of proofs that were brought in, that he spent the week, during the week in town, and the weekends were spent in sort of a reverse kind of situation. And that being the case, if you counted up the days, then he would have spent the time that would be required.
Right, all right. I mean, I think my criticism, if you want to call it that, is not exactly fair, because the issue of primary was not dealt with at all, so we're kind of stuck with
Right.
what we have.
Well, what we'd like to do is sort of utilize the, take from the rent stabilization. We looked at that also.
Yes.
To see what those proofs are. And with regard to the proofs of primary residence and our ability to do that, the ability to look at primary residence is in subsection 4 of our rules. And we have, by the way, looked at primary residence in the past. I don't think that our requirement to determine primary residence in this situation would be as, I can't think of the word, we wouldn't go into the proofs as much as, let's say, in an eviction proceeding in housing court pursuant to, what is it, 282A? The eviction for non-primary residence.
Oh, yeah, 208.
Okay, 208. And it's in the statute as well. So were an owner to bring non-primary residence in that situation, which we don't do, those proofs would be far more stringent than what we use. And so we say, okay, you've shown us your driver's license, your voter registration, your tax return, we've heard testimony from this person, and this person, that you lived here most of the time. So we're going to find that this is your primary residence. Just like we did for the woman who lived in the apartment, but she was Swedish or something, and she was a reporter, foreign correspondent. So she spent time outside, but she had no other address, and she spent a lot of her time here. So we have looked at primary residence before. We don't use the highest standard. And if an owner feels that person doesn't deserve protected occupancy and should be evicted because it's not their primary residency, then they can go and take them to court and ask for it. And that we don't do.
Right, thank you.
I mean, I think that's good. There's, the way it works in this country, everything can be suspect. I mean, you don't have to register to vote. Now, if you register to vote, you got the address there. But you don't have to register to vote. And anything else, you can get a driver's license in any state that you want, and so on and so forth. But, you know, you do the best you can. I
Let me just
understand.
say that there's a case called Ansonia, I don't have the whole citation, which held that you're going to hold the resident, the rent stabilized resident, to the address they put on their tax return, to what they put in official records to be their primary residence. So, for example, many times people have an apartment here in the city. They have a summer house that they go to on weekends. And when they got their mortgage, they couldn't get a mortgage unless that was their primary residence. So they lied, right? But this is where they live. But they wanted, to get the mortgage. So now these people who do that are being denied, would be denied coverage because in their legal documents, their primary residence is in Southhold or wherever. So it's, it's difficult. So Ansonia is the law, and that would be used in primary residence cases in housing court. Yes, Mr. Duvall.
I agree with Mr. Carter that I'm troubled by our kind of getting into making decisions about primary residence, and I question why it's necessary. And in this case, and certainly if we're going to start down this road, it would seem to me that it would better be a policy discussion by the board and perhaps the issuance of a rule rather than deciding in the midst of a case. And it's my understanding that it's well settled that primary residence is not a requirement for coverage. Would you agree with me?
I would say that it is well settled, Mr. Delaney, that primary residence is not required in coverage of a unit.
Correct.
And that's what those cases stand for. They do not stand for coverage of a person. It does not go to protected occupant status. Our rule is clear in what it says. And none of those cases that were cited by Judge Casey and have been cited ad infinitum by many other tenants' attorneys all cite for the wrong proposition. Vlahos, Boer, none of those cases stand for the proposition that primary residence is not required to be a protected occupant. They only stand for the proposition that it is not necessary for the unit to be covered.
Right, and the status of the protected occupancy in those cases is something that's handled by a court, not by us.
I don't think that the courts dealt with protected occupant status in those cases.
Right, no, it's not, but it's not, if in this case, let's take Mr. McCullough and Mr. Gorman, what if we had found there wasn't sufficient? We would have found the unit covered but not denominated them as protected occupants.
Yes.
And that would be based on our determination of what we think constitutes primary residence.
Yes.
Do we have a rule on primary residence?
No.
So we're just kind of going to make it up as we go along based on what we think sitting behind the oath judge. We're not even in the room.
We're making the determination if the record includes a driver's license or a tax return, evidence that usually indicates primary residence, we will use that.
And I could have my driver's license in New York City, I could pay my taxes in New York City, and I could spend 300 days at another residence somewhere else. And in a court of law, I would not be able to prevail claiming that my unit in New York is my
It would
primary
only
residence.
be if the owner could prove that you spent 300 days in someplace
Right.
else. And and owners are hard pressed to do that.
Well, I wouldn't necessarily agree with that.
Well, I would necessarily not agree with you.
But why are we getting into the business of making kind of, well, it's good enough for us to determine it's a primary residence, and what reliance can it take place on?
209B4, our rule says that a prime lessee who occupies the unit as their primary residence is the protected occupant of that space.
Right.
2062I also says that there's a clause there that was added that talks about primary residence. That's the authority. That's the authority that we have.
2062I,
Yes.
could you just put that in a tiny bit of context?
Sure.
Kelly, can you pass the law again?
Oh, it's right.
Do you need more cups?
We're good.
Okay, it says residential occupants qualify for protection pursuant to this article shall be entitled to continued occupancy provided that the unit is their primary residence.
And if the unit's not their primary residence, that's the case, that's a matter that's determined in court.
See, I'm not even, I don't, I mean, this argument seems to be, I mean, I'm not even sure that Donald Trump spends most of his time in New York City. His house is all over the country. And he claims that he's probably here in the city, so I don't think, even if he's not here 300 days a year. So I think that this argument is not going to lead us anywhere. Well, he's the primary resident, and I didn't necessarily leave it alone. You know, the Hebrew, Israeli writer Amos Oz has once said, if anybody's stupid enough to call themselves a Jew, they're a Jew. So let's just, just leave it at that. I mean, if you feel bonded to the city, then that's your primary residence. Now, I noticed that among the people that we looked at, there were several granddaughters and grandsons, rather significant people. One was Errol Sheridan, the other was Barnegat, another was a son of a woman who's the congresswoman from Maine. Maybe the other was Paul Rudd, who maybe left to move to California, etc. Well, who knows what it is? I mean, somebody like Paul Rudd, would be in Hollywood half the year because that's what he's doing. He's making movies. But I guess he left his thing. But if he says he's a New Yorker, why let's just forget it and let it go ahead.
Mr. Barrows, we've taken people who have been out of their units for
I
2
know
or 3
that.
years,
That's right.
and they were on location making a
That-
movie or teaching in
Teaching
some other
somewhere,
college,
right.
and we say that person, this is their primary residence. We don't count that against them. We don't hold it against them. Okay? So we are trying our best to follow the rule and to make some sense out of the rule so that people know what to rely on. Okay? So, Mr. Carver's question about, well, what are your criteria for primary residence? That's an excellent question. And what will happen is this will be filled out for us rather than rulemaking by case law, by our orders, which will indicate what people should do when they're at oath to prove not just that that it was residentially occupied during the window period and it meets all the eligibility requirements, but that if I'm claiming protected occupant, I say, and yes, I've lived here and I vote here, here's my intent, I pay taxes here, here's my address, and oh, I have a house in Southold, and that I told them on the mortgage, I was my primary, but that was just for that. And so we'll look at all of that, because again, it's not the strict standard that would be presented at Hazard. We're still trying to take in as many people as we can and make people protected occupants where we can abide by the rule. So we, to say, as has happened sometimes in the past, you're living there, come on in. Yeah, you're a protected occupant, why not? No, we cannot do that. There's too much at stake. There's too much value in being the protected occupant of these units right now. And so therefore, we think that we have to give more care than just saying, come on in.
If I may, following along that line of questioning, we saw a case on the summary calendar today, two of them actually, where the board, in dealing with coverage coming out of both, developed a concern that an individual was not a protected occupant. But the landlord said, you know what, I'll register that person as a protected occupant. In which case, that's okay.
And that's up to the owner to do. That's not up to us. If the owner wishes to give that person, which in this case, let's take Ms. Gui, for example. So Ms. Gui, who the owner originally did not wish to make a protected occupant, I don't know why, but he actually did not want to do it. He was persuaded to do it anyway. Okay? So there are many ways that people can become protected occupants. That was one of them.
And this is why I believe it's a disaster to let this protected occupant issue bubble along on a case-by-case decision. If the board wants to start saying, we're going to look at protected occupant, we're going to look at primary residence, not with regard to coverage, but with regard to entitlement to being a protected occupant, then the board should promulgate some kind of what you want to bring to oath.
Mr. Delaney, that's what we're doing right now. You do not necessarily have to come and make a new rule, which would make it even more complicated. And I think we went through this a while back before Mr. Carver was here with this whole outline of what the rule said and how it should be configured. And we discussed at that time the concept of creating a new rule. And what we have here, the way we are interpreting it now, really takes care of almost every situation. It may not be an absolutely, a win-win for everybody, but nothing ever is. But this rule is as good as it's going to get, I think. It was a very hard rule to draft, and so I would say to you that what we're doing now in interpreting the rule is creating creating case law, which will permit everybody to understand how the rule is going to be used.
And the rule that you're referring to is 209.
209.
Right. And that, I just want to be clear, because it was, when you said, oh, come on in,
That rule was there, and it was
Well,
ignored.
no, just for context.
It was ignored.
What you were referring to was, in that tone, was in that little vignette,
Yes.
was prior board precedent.
It was prior, I don't think that you could really call it precedent, because the board didn't do any analysis. It said, this is a unit, this is a unit, this is a unit. And these are the reasons why. And oh, you're all protected occupants. And there was no analysis.
The protected occupants offered proof that they lived.
There was no analysis in the orders. None. On many of them. Some of them had it, but many of them did not. Okay? So it was, it was a shrub.
Okay. All right. So let's take a look at some of the people that aren't protected occupants. Page 7, we have Ms. Rivera, who's Mr. Wetter's wife, and she apparently occupied the unit through the period.
Yes, she did.
But she doesn't hold the lease. Mr. Wetter holds the lease. So we say she's not a protected occupant at this time.
Right.
Although Mr. Wetter's spouse occupying the unit, as Mr. Wetter's spouse occupying the unit as her primary residence, she is entitled to succession rights in Mr. Wetter's absence, pursuant to 2081. And this is a new one on me, and she will be entitled to be named on the initial lease that issued upon removal from the law board's jurisdiction.
You didn't know that?
She's entitled?
Yes, under rent stabilization law. under the rent stabilization law, she can continue with that. But she's not under the rent stabilization law yet. She's under our rules.
Right, but so you're saying per the rent stabilization law.
Pardon me?
You're saying that she would be entitled because of the operation of rent stabilization?
When they get their first lease, she's entitled. It's, okay?
Which is in language that we didn't put in the Franklin Street case, where we first determined that the husband with the lease is the protected occupant and the spouse is not.
Well, once the building is removed, they don't, just because we didn't put it in the order, it's not something that would bar the owner or the tenant to request of the owner to add the wife's name.
Right. All right.
Can you make a motion now? Please. No one else? Sorry. So, is there a motion? To accept this case, Michelle? Do I have a second? Mr. Chapman?
Mr. Carver?
Yes.
Mr. Bowers?
Yes.
Mr. Gregory?
Yes.
Chairperson Fisher?
Yes.
Mr. Delane?
No.
Ms. Golden Rivera? Yes. Mr. Jackson?
Yes.
Ms. Shelton?
Yes.
7 in favor, 1 against.
Thank you, motion passes. The second coverage case is Anna Villarota, 155 Suffolk Street, TR. Ms. Cruz, please present this case.
In this case, Anna Villarota, the shareholder of the owner of 155 Suffolk Street, filed an application seeking Article 7C coverage. Ms. Villarota owns shares of the 4th floor rear unit and the 5th floor. The applicant filed an amended application seeking coverage under 2 theories. Under the first theory, she sought coverage for 3 units, 1 unit each on the 2nd, 3rd, and 5th floors, pursuant to MDL 281. Under the second theory, she seeks coverage for 4 units, 1 unit on the 3rd floor, the 4th floor rear unit, and 2 units on the 5th floor, pursuant to MDL 281.5. In the report, Judge Spooner recommended a finding that the building is covered pursuant to 281.1 with 1 unit each on the 2nd, 3rd, and 5th floors, and that the 4th floor rear unit is covered pursuant to MDL 281.5 and 208G of the Loft Board rules. The staff recommends that the board accept Judge Spooner's recommendation with regard to the 2nd floor, the 3rd floor, the 4th floor rear, and the 5th floor unit. There's no dispute that throughout 1980 and 1981, the 3rd and the 5th floors were residentially occupied. However, the parties did dispute whether the 2nd floor was residentially occupied during the MDL 281.1 window period. The applicant presented 2 witnesses and documentary evidence. The applicant's first witness, Richard Gombard, testified that he lived on the 2nd floor from 1974 until the summer of 1977. Mr. Gombard testified that when he moved out of the building in 1977, he sold his fixtures to Stephen Kabrowski. The applicant's second witness was Gary Kabrowski, Stephen's brother. He testified that Stephen lived on the 2nd floor from 1977 to the end of 1981. The applicant also presented certified copies of the New York telephone book listing Stephen Kabrowski at 155 Suffolk Street from 1978 through 1982. 2 of the other shareholders testified. The shareholder for the ground floor testified that he owned the 2nd floor units in 1980. He testified that prior to 1982, the 2nd floor was used for storage and that he did not know Mr. Kabrowski. The other shareholder testified that he lived on the 3rd floor in 1980 and 1981, and that the 2nd floor was used for storage, but that he also testified that prior to 1982, Stephen Kabrowski lived on the 2nd floor. The staff recommends that the board accept Judge Spooner's finding that the documentary evidence and the credible testimony are sufficient to establish that the 2nd floor was residentially occupied during the MDL 281 window period. The staff recommends that the coverage be granted under the first theory. Regarding the 4th floor unit, the staff recommends that the board grant coverage pursuant to MDL 281.5 as an accredited unit under 208G1 of the Loft Board rules. The rule provides coverage pursuant to MDL 281.5 for units in a building subject to Article 7 pursuant to 281.1 or 4 only if the unit is not already covered under 21.1 and 4, and if the unit meets the eligibility criteria for coverage under 281.5. There's no dispute that the fourth floor rear unit meets the eligibility criteria for coverage. The only argument against coverage is that the other shareholders did not consent to the residential occupancy of the unit. However, it has been established that consent to the residential occupancy during the window period is not necessary for Article 7C coverage of the unit. Finally, the staff recommends that the board grant coverage for one unit on the second floor and third floor and the fifth floors pursuant to 281.1, and grant coverage for the fourth floor rear unit pursuant to 281.5 in the Loft windows.
Thank you. Questions or comments?
This building seems to have gone through a lot of complicated legal stuff. Is it now owned as a co-op?
It always is,
It always is.
as far as
And therefore, we're finding covered under covered under Article 7C, which will require the building to be brought up to residential code. But we're making no determination as to protect the occupants.
no, the claim was made.
Right?
The claim was made.
Nobody made a claim for protected occupancy.
No one made a claim.
Yeah.
Any other questions or comments?
Do you need water, Mr. Rivera? No.
Is there a motion to accept this case? Ms. Shelton, do I have a second? Mr. Gregory? Mr. Rivera?
Mr. Cover,
Yes.
Mr. Barber,
Yes.
Sorry.
Mr. Gregory,
Yes.
Chairperson Fisher,
Yes.
Mr. Delaney,
Yes.
Ms. Golden Rivera, Mr. Shackman,
Yes.
Ms. Shelton,
Yes.
8 in favor.
Thank you. Motion passes. The third coverage case is Kyle Doris and Monica Hernandez, 143-155 Woodland Street.
March 10th and March 11th of 2014, the occupants of Unit 1-4 and 1-8 of 19 Grove Street filed applications seeking Article 7C coverage pursuant to 281.5. After a conference, the parties agreed that the only contested issue is whether the units have a window that meets the eligibility criteria for coverage in 281.5. In the report, Judge Casey recommended Article 7C coverage for the units. Specifically, Judge Casey found that the window in Unit 1-4 opens onto a court, and that the window in Unit 1-8 opens onto a yard, as those terms are defined in the zoning resolution. The staff recommends that the board accept Judge Casey's recommendations regarding coverage. Owner's only argument against coverage for Unit 1-4 is that the area on which the window faces is not a native court because there's a section of the area that's partially obstructed by a covering. This covering is attached to the building's facade on 3 sides and blocks the area in front of the window from being open to the sky. And the pictures in the record show that the covering is not a structural part of the building, does not appear to be part of the original construction of the building, other than the area immediately adjacent to Mr. Doris' window. The area outside is open from the lowest level to the sky. The owner's arguments against coverage for Unit 1-8 also fail. There's nothing in Article 7C or in the zoning resolution that requires a lawful yard to be located either partially or entirely in the same zoning lot as the unit, or that the owner of the unit seeking coverage also be the owner of the yard. The staff recommends that the board grant coverage for Units 1-4 and 1-8. Lastly, regarding under the heading of findings and conclusions, Judge Casey recommends a finding that Mr. Doris and Ms. Hernandez are protected occupants without any analysis. The coverage applications did not raise a protected occupant status claim, nor was the claim an issue in any of the submissions to Judge Casey. The staff recommends that the board reject the recommendation to find that Mr. Doris and Ms. Hernandez are protected occupants.
Thank you. Comments, questions?
So here we have 2 tenants who applied for coverage for their units. We're finding the units covered. We're finding them not to be protected occupants.
Well, we didn't find them not to be protected occupants. We just didn't reach it. It's not claimed, it
Right.
wasn't alleged, it wasn't discussed, or nobody, no notice was given to the owner that they made the claim, so we don't go to the claim. There's no claim.
And the fact that ALJ Casey writes that his first paragraph applies to the board for findings that they're each a protected occupant of an interim multiple dwelling, that's just Judge Casey being sloppy.
Well, I would not characterize Judge Casey. I'd just say that it wasn't in the transcript, it wasn't in the papers. No, I know that he wrote it.
Right.
You're holding up like I'm not believing you. No, I know that
quite
he
the
wrote it.
contrary, no, I'm just.
I wrote
looking up.
it. He might have found that, but we don't know why in the world he would, since it wasn't alleged, wasn't pleaded, wasn't in any of the papers.
Well, the logic that I'm going to pay a boatload of money to a Loft attorney to get my unit declared covered, but to be silent on the subject of whether or not I'm a protected occupant seems curious at best.
Well, maybe, Judge, we shouldn't characterize Mr. Casey as being sloppy without characterizing some other people similarly.
Well, I guess this is again, what I find inefficient and kind of wasteful is again, if Mr. Doris had filed pro se, if he'd added a sentence and said, I want to be found to be the protected occupant, what would we have done differently? What would Judge Casey have done differently?
Well, he would have written an analysis under 28209 to explain why he would find Mr. Doris a protected occupant.
I see.
And the owner would have noticed that that was a claim, that Mr. Doris was claiming protected occupancy, which there was no notice to the owner of any such claim. And that's, we cannot make up stuff. We religion, we make up a lot of stuff. We don't make this stuff up. Mr. Berger.
Would you say that it's accurate to characterize the judge's decision that with respect to that particular protected status as being sua sponte?
Mean that he came to it of his own
Right.
accord? Well, he came to it of his own accord, and I don't characterize it as sloppy or a mistake or whatever reason he had. I don't know. But I can tell you that having read the record, all of the papers, all of the transcripts, there was no reason to find so, and so we don't find so.
So I'm a little troubled. If someone's window opens up to the courtyard and you don't actually own the courtyard, what happens if someone's building on the property line? Like,
I'm sorry, what?
if the window opens into a courtyard and you don't actually own, if the adjacent property owner has the right to build up to the lot line as schools do some of these institutional uses, then what happens? Do you lose your status because it's not,
No.
doesn't have physical criteria anymore?
The facts in this particular case is that the owner has built
General
up.
question. Get the facts.
The general question is that the concept of using somebody else's zoning lot for this purpose gave us a great deal of pause. So we didn't just take the expert's testimony or the allegations or the papers. We went to both the borough commissioners of Brooklyn and Manhattan to determine whether or not this was a viable thing to do. And what we found out was in the multiple dwelling law and in a technical policy and procedure notice that DOB had issued in 1993, DOB said that for IMDs, or in the case of the MDL for 7B units, you could use the adjoining lot if you didn't have enough space on your lot. Now, in this particular case, we know that the adjoining lot is a residential lot, so they can't build to the lot line. Okay, so we know that that's going to stay the way it is. But we gave a great deal of thought and research into, but someone could
buy that residential property and turn it into a school and build a lot line. Then what do?
Then you have an IMD unit that's got no light and air, but it will still be an IMD.
That's the problem.
You know,
But it doesn't deregulate it.
I know.
And then there's a portion of multi-dwelling law that gives the borough commissioner, gives DOB the opportunity to issue a waiver of certain things. They said to us, if you're coming right up to the lot line, we get it. If you've got a foot or two between the building and the lot line, you know, in certain circumstances, we're going to, if you ask, we're going to let you, you know, that'll be okay. Because we have other cases coming down which have the same analysis, where they use somebody else's line. I thought it was crazy. I thought it was nuts. I mean, what's with that? Because I thought just like you.
Where you can borrow somebody else's property to meet your requirements.
You know, I thought that Martha and I had a number of arguments about that, and then I went to find out exactly what DOB, who is the one who makes these judgments.
I mean, it's a sad you can't get out.
well, that's another.
That's a second means of egress issue.
That's another issue.
Most of the time it's the window.
It's the first floor, and it's first
Well, you know, but
And
this
in the neighborhood,
happens,
it's the window.
Leon, this happens all the time. And what happens is that room is now designated as an office rather than a bedroom. I don't know how many lofts I've been in, where they built up to the, you know, where there was a parking lot, and then a building goes up, and they lose all of the side windows, and they're lucky if they have a front and a rear window. But right now, that's all you need. I mean, there was a point where you could not build a bedroom up to the ceiling.
They left
Left a little space, so you have light and air 30 feet away, or 50 feet away where
For
the
that
window
one
is.
window, yeah.
I mean, that great case that we had with this double transom, remember that? That it was a ground floor building and it had a double transom. Transom in the front door, a small little hallway, and another transom, and that made the space legal. And I'll tell you, the old law tenements, these old first tenements that were built up, they were generally built up with an air shaft. So one bedroom had really light and air, it was an air shaft. They didn't build on the air shaft. And now we find that almost we're regressing to a certain degree. But anyway.
In your consultation with the Borough Commissioners of Brooklyn and Manhattan, have they referred you to a document?
Yes, this is what they sent me. Borough Commissioner sent me that yesterday.
Could you distribute that document to the board sometime in the next month?
Sure.
So that we can read it before the next window cases come?
Sure.
Well, thank you. So with regard to Kyle Doris and Monica Hernandez, they've succeeded in their case such that their units are now determined to be covered. So their next step, if they themselves want to become protected occupants, would be to file a protected occupant application.
Well, Mr. Clay, why don't we wait to see whether the owner registers them as protected occupants or not before we determine whether they would have to file a protected occupant application.
Let me phrase my question differently. Were the owner to register the units and not name them as protected occupants, then their recourse would be to file a protected occupant.
That is correct.
Anyone else? Comments, questions? Is there a motion to accept this case? It's number DR 1196. Michelle, thank you. Is there a second? Mr. Gregory, thank you. Mr. Rivera?
Mr. Cochran.
Yes.
Mr. Barber.
Yes.
Mr. Gregory.
Yes.
Chairperson Fisher.
Yes.
Mr. Levine.
Yes.
Ms. Golden Rivera. Yes. Mr. Shacker.
Yes.
Ms. Sheldon.
Yes.
8 in favor.
Thank you. Motion passes. Finally, we have 3 removal cases that are voted on as a group. They are 360 Broadway LLC, 360 Broadway, LE 0659. Gramercy 128 West LLC, 128 West 23rd Street, LE 0660, 109 Green Street condominium, 107-11 Green Street, LE 0662. Comments or questions on these? Is there a motion to accept these cases? Shelton, thank you. Anyone else? Mr. Carver, thank you. Mr. Rivera?
Mr. Carver.
Yes.
Mr. Barber.
Yes.
Mr. Wainwright.
Yes.
Chairman Fisher.
Yes.
Mr. Devine.
Yes.
Ms. Walter Rivera. Mr. Shelton.
Yes.
Ms. Sheldon.
Yes.
Mayor Bailey.
Thank you. Motion passes. This will conclude our March 17th. April. Sorry. My fault. Let's say April 21st, 2016 Loft Board public meeting. Our next public meeting will be here. No, I think it may be here actually, so stay tuned. On May 19th at 2 p.m. Thank you. Board members, please sign in your attendance.